Hello and welcome to Play On, the Morgan Sports Law podcast. I'm Tom Seamer, a barrister at Morgan Sports Law, and I'm joined today by my colleague Mario Flores Chemor, who sadly will soon be leaving us to take the role of Head of Legal at the European Club Association. We are very happy to today be joined by two special guests. Firstly, we're joined by Leticia de Bergia. Leticia is a lawyer at the Spanish Football Federation and previously worked for 6 years at FIFA's Player Status Department. Leticia has been at the RFEF since 2018, where she leads the Player Status Department and deals with international legal matters. Second, we're joined by James Kitching. James is FIFA's Director of Football Regulatory. James was previously the Head of Sports Legal Services, Disciplinary and Governance at the Asian Football Confederation. Today, we will be discussing the recent amendments to the FIFA eligibility and change of association rules. James, perhaps first of all, could you give us a brief introduction to the rules and a brief explanation as to why FIFA felt they had to be changed at this point?
Thanks for the question. Long story short, the existing rules that were in place had not undertaken any form of review or modernization process since at least 2008. The history of the rules themselves are actually quite simple. Since at least the early 1990s, there's been formal rules governing the eligibility to participate for representative teams or national teams in the FIFA statutes. Before, the history of the relevant provisions are a little bit murky, but at least since the 1990s, we can see that. First instance, it was merely just as long as a player held nationality, they were eligible to play for the representative team of the Football Association. The rules evolved over time based on certain issues that popped up from time to time, as you can imagine. The legislator makes a rule and those that are subject to the rule do their best to bend the rule as much as possible. The rules that we saw before the amendments a few weeks ago were really formed between 2004 and 2008, and they govern specific scenarios relating to, in football, what we call common nationality, as well as where an individual acquires a new nationality. But in the intervening 12 years, there's been a number of inquiries from associations and stakeholders over the meanings of certain provisions, over the interpretation of certain provisions as well, in terms of does this fit within the rule or does this not fit within the rule. So it was decided to implement a working group in the middle of 2019 to examine the rules as part of a modernisation process. That working group came up with a number of recommendations. They were sent to the Football Stakeholders Committee in February. The Football Stakeholders Committee subsequently endorsed the principles that were established by the working group, and subsequently draft regulations were produced for the Council, which, following a small process of amendment, were endorsed and sent to the Congress for approval. And I'm very, very happy that the Congress on the 18th of September decided to refresh these rules. In that respect, that's how we got from where we were to where we are now.
Well, thank you, James. That's a very helpful introduction for our listeners and for us as well. If we discuss eligibility, first of all, and then the question of nationality, Article 5.2 of the rules now distinguishes between holding a nationality and being eligible to obtain a nationality. So if I could ask you, James, what was the purpose of that change? And is there a definition of nationality for the purposes of Article 5.2?
Good questions again. The first thing I'll give is a global disclaimer. Hopefully coinciding with the release of your podcast, we will also be publishing a commentary on the eligibility rules, which runs through each provision line by line and explains things which might not be clear. So I'll do my best to capture what's already in the commentary when answering these questions. But if there's any discretion between what I say and what the commentary says at a later stage, the commentary prevails. Lawyer disclaimer. But firstly, on nationality itself. So the rules themselves have historically referred to nationality, and nationality itself, as you know, in public international law has a specific meaning. I think it was the case of Notabum by the International Court of Justice to define nationality as a legal bond between an individual and their nation, their country. Generally, that legal bond is demonstrated through holding of a passport for international travel. So what FIFA does is, through its competition regulations first, it requires proof of nationality to be provided to allow an individual to participate for a representative team in international competition. And that proof is the holding of an international passport. So we link the holding of that international passport back to nationality itself. And so that's where we define nationality through, or have the meaning of nationality as it's interpreted through our rules. Holding a nationality is something very specific. So the original FIFA language in the rules has always been that the player holds a nationality. So that has been maintained in the updated rules. And the distinction between holding a nationality and eligibility to hold a nationality, probably this is the most requested provision that we receive inquiries about from associations prior to these changes. Is this player holding a nationality or not? Because obviously if a player holds a nationality, then they may be potentially eligible to play for the national team. What we say the distinction is, as you see in the rules themselves, we say the distinction is without being required to undertake any further administrative requirements. So what we'd say there, automatically holding a nationality generally means that under national law, whether it's through the principle of jus solis, which means nationality is linked to place of birth, or jus sanguinis, nationality is linked to the nationality of your parents. Under one of those two principles, generally almost every country around the world will provide nationality automatically to an individual. The other element requires that the automatic grant of nationality does not oblige a player to undertake any further administrative requirements. So what we say are further administrative requirements in this context, certain formalities connected to childbirth before the nationality is automatically granted. In some countries, for example, you might need to register the birth to actually be considered a national, or if you're born abroad, you might need to register at the embassy or just send a request through. We don't consider that these formalities connected to childbirth would be considered further administrative requirements in the meaning of the rules. However, if the national law provides what we call a substantial precondition prior to the automatic grant of nationality, so for example, an individual has to abandon another nationality, there is a significant waiting period after childbirth. Some national laws say that the waiting period has to be 10 years, for example. This, in our view, would be considered a further administrative requirement. So in that respect, where there's that substantial precondition that we talk about, that's what we would consider a player being eligible to obtain a nationality as opposed to holding a nationality itself.
Thank you, James. Leticia, how do you think that member associations, including your own, will perceive the change in the rules? On balance, do you think it's a good thing?
Thank you, Tom. Yes, indeed, I think it's a good thing in general, right? I mean, of course, it will depend a lot, between countries. I mean, and each country has its own national regulations about acquisition of its own nationality, but it's for sure a good thing. I mean, in Spain, for example, the Spanish nationality can be received if when you are born, any of your parents already have the Spanish nationality. Also, if you're born from foreign parents, but one of them was born in Spain, even though that parent does not have the Spanish nationality, you can also receive the Spanish nationality. Like you have the right to it, right? Without any further administrative, as in the sense that James just explained. It's easier, I would say, from a member association perspective now. This difference that the regulations make, I say that depends on the countries, right? But for example, in Spain, this process of acquiring the nationality, which I just explained, are quite easy and straightforward. So I don't believe we have this gap of 10 years that James explained, for example, in some countries. If you are born or if you comply with these two cases that I just explained, you can always ask for the nationality without doing any further administrative steps. What it is a bit more complicated is the naturalization process. Again, speaking of Spain, so this involves a final decision of the government in our country. So this implies a lot more steps to be taken, more documentation to be provided, etc. Right? But in the end, I think it's a very positive and a very positive change in general.
And focusing on the naturalization procedure in Spain, I was wondering, is the RFEF planning on establishing, or might already have established, a procedure to be sure that a player has completed that naturalization process? Is there a checklist of documents that are sent out to check that?
Yeah, well, actually, we already had before this new regulations came into force. We had already started with this kind of due diligence, internal due diligence process about the nationality of players, right? It's a process where the legal area, the competitions area, and the sporting director of the federation, of the Spanish Federation, participate together with the clubs where the players are playing, right? Because they are the ones that have the closest relationship with the players, with the relatives of the players, etc. So yeah, it's a kind of a checklist, exactly, the kind of a form that we provide the clubs with, and they just reply with information that we ask, documents that may have to enclose, and yeah, we could say that this is like the first step that we take, that the Spanish Football Federation takes in an eligibility process.
Now, Mario, James said that issues typically become apparent in regulations when lawyers start pushing around at the edges of those regulations or challenging those regulations. As a lawyer and as someone who's obviously thought about these new regulations, what do you think are the potential grey areas or the areas for dispute or different interpretations?
I think that James' explanation was quite clear in the sense that now, for what I understand, is what FIFA will analyze is whether there are further substantive steps that a player should take. For example, either prove that he has lived in the country a certain time, or to prove that any administrative steps is actually related to his stance as a person, let's say, rather than just go and register any kind of paper or fill out any kind of form that they need. And the key here that I see is the operation by operation of the law, and that's what is key in this article, in my view, because it seems that even if it speaks about administrative procedure steps, those administrative steps have to be related to the actual part of substantial issue, not only a step that needs to be taken, as I said, to fill out form. For example, the point of being born in a country but not being entitled to the nationality until a certain time has lapsed. Those would be actually a part of a substantive point of the person in a specific country rather than purely administrative steps, as the regulation would appear to say. So I think that point is clear in my view that whenever you are analyzing the eligibility of a player in order to see if it's only an entitlement to a nationality or already holding a nationality, the analysis should be made as to if there is any substantive steps that the player should still take, or that only as it is now in that current stance, he's already holding because of the law says that he already does. And what would be interesting to say is that I say there's a lot of, I would say, a gray area in this respect, because what could say, well, what is a substantive step or what is only a fill out of form? And what would be interesting to see is if the process before the PSC, as far as I understand, eligibility is usually not a process in itself. If I just say, well, it's the national FA that is responsible for being if this player complies. If process related to this actually particular point, FIFA could actually clarify a bit further and to say, well, I think this player is not only holding a nationality, but it's only entitled because X, Y, and Z. Let's see if of course, if that's the objective of FIFA with this provision or not really. But I think there's enough gray area that could potentially entail that FIFA is a bit more, it gives more clarity given the specific case.
Yeah, well, I expect you'll have to wait and see the clarificatory document that James has said is coming out soon.
Exactly.
Looking forward to it.
Okay, moving on then to the acquisition of a new nationality. Article 7.1d of the rules, which is the old 5-year rule, now provides for different time limits depending on the age of the player. And it also transpires from Article 7.2 of the rules that only players between the age of 10 and 18 are obliged to submit a request for eligibility to the Players' Status Committee, the PSC. So, James, first of all, please, what is the purpose of those amendments from FIFA's perspective?
Sure. So now we have, in addition to the existing rule, which was the requirement to live on the territory from the age of 18 for at least 5 years, we have two additional temporal requirements, as you mentioned, linked to age. 7.1d 7.2, which is the age requirement between the age of 10 and 18, and then the subsequent requirement in 7.2 for someone making an application under that requirement to go to the Player Status Committee. That is the codification of an existing unwritten rule. So there was always an unwritten exception. Well, not always, I'll say, but there was an unwritten exception to the existing 7.1d in the FIFA rules, where a player that had lived on a territory for at least 5 years before turning 23 could demonstrate that the move to the territory was not for the purposes of participating for representative team football, could seek an exception to 7.1d of the existing FIFA, or the previous FIFA rules, I should say. So that is a codification of the jurisprudence, provide legal certainty to stakeholders. It was an unwritten exception which wasn't known to many associations and may have been utilised if possible. So this provides that clarity there. The time limit and the age restriction for a player that begins living on the territory before the age of 10 of 3 years, this is considered in the context of someone that moves before the age of 10, with or without their family, but obviously always usually with their family, to a territory, is generally not going to be doing so for the purpose of playing for the representative teams of an association. And as such, a 3-year requirement of continuous living on the territory, I should say, is deemed suitable. When you take into consideration, actually, in that respect as well, that representative team football, at least in official competitions, doesn't generally start in federations anyway until under 15 or under 16 level. And we don't deem that it's necessary for someone that's moved that young to have to go through an administrative process because of the unlikelihood that move was for football reasons as opposed to real life reasons, I would say.
And following up on that, I can quite see why FIFA's view is that players under the age of 10 shouldn't need to go through that PSC administrative process for the reasons you've just explained. What about players above the age of 18? Because from my understanding of the rules, they also don't have to submit a request to the PSC.
That's right. So again, this is the existing rule. And quite simply there, when the player is an adult, the responsibility is on the association to undertake its due diligence to ensure that the player is eligible to participate for its representative teams. It depends on the time for when the player actually began living on the territory as well. So it's not necessarily, as you say, if a player is over 18 not having to go to the Player Status Committee. There may be a situation where an application is made for a player that began living on the territory between the age of 10 and 18 at a later stage. So just on that particular point, again, for players that came as an adult to a territory, it is the responsibility of the association ultimately to determine whether a player is eligible to participate for its representative teams.
And if a player doesn't submit an administrative request, will that make them ineligible to play for the relevant association, even if they do in fact comply with the requirements of Article 7.1.d?
D2, yes, exactly.
And Leticia, from your perspective, do you think that the amended acquisition of new nationality regime could lead to any uncertainty as to which players are eligible to represent a national team? Or do you think that it's all sufficiently certain?
Well, first of all, thank you, James, for that, because I was really looking forward to listening to you in this regard, because I also think this article is very related with Article 19 of the regulations of the status and transfer of players, right? I mean, where players under 10 do not have to do not have to request an ITC, and players over 18, of course, are not already minors, so they can move freely. So thank you for that, because I was really curious. And as to your question, Tom, so I don't know if I would call it uncertainty. I think it's quite clear. Even I mean, it's even clearer. What I think it is it's a bit of an add-on of items to checklist of eligibility factors, right? As well as to the process of eligibility, which is already maybe quite cumbersome. I think it would help quite a lot if at least FIFA could explain or define what a request for eligibility consists in, because it's a procedure or process, right? That it's not really defined along the regulations. There's always being a bit of uncertainty in that regard. Speaking of processes, I mean, of the administrative process. If this article it gives uncertainty as to which players are eligible, I don't think so. I think more the contrary. I think it clears a lot the path, right? But anyway, I think we will have to wait for the practical application, right, of this article and see whether this purpose is really met.
If I can jump in there, sorry, I'll just say as well that yes, Letty's absolutely right. There has been I would say, a void in the past when it comes to processes relating to eligibility decisions of FIFA. We're also in the process now of updating procedural rules for what we now call a request for eligibility on the one hand, or a change of association on the other hand. So hopefully we'll be able to send those out soon.
Great. That from a member association perspective, it's going to be really welcome.
Mario, do you agree with Leticia? Do you see no uncertainty there, only certainty?
Actually, Leti took the comment from my mind, because I was actually thinking about the relation between, and if there was any, between this new Article 72 and 3 and 1 and the minor provisions. And I think the relation is clear. What I was thinking also, though, it's about this living in the territory, that now there's also further clarification in respect of when the living in a territory is interrupted and when it's not. And I think this would also give a bit of grounds to actually challenge a potential specific case or to argue a specific set of facts.
It's a really good point by Mario. And previously, the wording of the regulation required continuous living on the territory. Now it just says lived on the territory of the relevant association. And along with holding the nationality, this was the other phrase in the regulations which caused the most consternation for our associations. What does living continuously mean? What does living mean? Does it mean residence, physical residence, fiscal residence? That there was a lot of, I would say, creative and constructive ways that associations tried to tie in a player living to a territory. So that's why it was necessary for us to make that definition and to also make a link between what are permissible absences from a territory and also what are non-permissible absences. We limit it to a period of physical presence, and notwithstanding the permissible absences, we set a hard deadline for the minimum amount of days that are required to be spent on the territory to be considered to have lived there for a full year. That was 183 days, and that is generally in line with residence laws around the world, which basically say someone is a resident in this country for a period of a year if they spend more than 6 months in the country. So although it's not directly referencing any national laws, of course, but that was the logic that went into developing that particular provision, which, and to be fair, the matters which Mario raised about football, off-season, holidays, absences for personal reasons, these were again also matters which FIFA would take into account when asked by associations, is my player resident or not? But they were in an unwritten way. And so that's why it was important for us also to provide some certainty there for stakeholders. And I'm looking at the commentary draft now while giving this explanation. And this is a pretty long section, so I hope Letty will be happy with what we produce on this part.
Yeah, for sure. But also in the drafting of this article, right? It doesn't seem to be relevant. I don't know, James, if I am wrong in this interpretation, but it does not appear to be relevant that this period of time of physical presence, no, or living in a territory as it's established, that this period is the last. So these 3 or 5 years are the last 3 or 5 years, right? Mm. Am I wrong, or it's?
That's a good question. It's one which is also in the commentary, and in our view, it doesn't need to be. If a player meets the relevant requirements at any stage, then potentially they are eligible. You know, we had actually a situation involving a player that asked us this exact question about a week ago. So so that's why I can be confident in giving you the answer, because the player had done his 5 years in one territory, had got the nationality, but then transferred to another club somewhere else. So the question from the association of his former club was, is this potentially a case where we can still call up the player? So that will also be covered. I'll double check to make sure we definitely keep that in our commentary for you.
Thank you, James.
Yes, thank you, James. And we look forward to seeing the commentary when it's finalised. Let's move on now to changes of association. And if I could ask James, first of all, to continue this structure, in general terms, what's changed there under the new rules?
Those who are not familiar with rules would generally know that in football, the rule is once you've played for the senior national team of an association, you cannot change association to play for another country, for another football association in representative team football. There used to be, well, there still is, but under the previous rules, the exception was that a player was able to change association even if they had played for the representative teams of another association, except the A team. If at the time of their first match for their current team, they were a dual or multiple national. So they had the nationality of the association that they wished to represent. That's still reflected in the Article 9(2)(a). That's the existing exception which allows the player to change association to another association despite having already played or been fielded, is the words we use technically, been fielded in a match in an official competition. And just to clarify, an official competition for the purposes of the FIFA statutes is a competition organised by a confederation or FIFA. So that existing exception allowing a player to change association is still there in Article 9(2)(a). Now, what we have done is we've introduced a number of other limited exceptions. The first one is the exact opposite of the case that I've spoken to you about, which is where a player plays in an official competition for one association, but he's not a dual national, or she's not a dual national or multiple national at the time of their first match. We now provide an exception in our rules where, as long as the player's last match in an official competition in any kind of football for their current association was before they had turned 21 years old, and they meet any of the requirements provided in Article 6, which covers common nationality, or Article 7, which covers acquired nationality, then they would be eligible to change association. In that respect, here is a case of a player acquiring a new nationality generally, as opposed to a player, like I said before, not being a dual national. The second exception is an exception which permits a player in very, very limited circumstances to change their association where they've played in an official competition at A level. So you recall that the general premise of the rules is once you play at senior international level in any kind of football, so that's football, futsal or beach soccer, your sporting nationality is tied to the association that you have represented. In this case, we will allow a player to change association to another, despite having played at a international level, with some very limited restrictions. So the first time they played at international level in an official competition in any kind of football, they were, again, a dual national. So they held the nationality of the association they wished to represent. Their last match for their current association in an official competition in any kind of football, they could not have turned 21 years old, so they have to be below 21 years old. At A level, they must have played no more than 3 matches, whether that's in an official competition or a non-official competition, so friendly matches or a regional tournament, etc. There's a waiting period of 3 years from their last match at A level until they are permitted to change association, whether that last match was in an official competition or a friendly, and also that player never participated in the FIFA World Cup at A level for their association, or what we call the final tournament of a confederation competition. And just to clarify that, because like I said at the top, associations are asking us questions to try and bend the rules already. We've clarified that the final tournament of a confederation competition means the premier tournament. So, for example, in Europe, we're looking at the Euro for both men and women. We're not looking at Nations League. Similarly, in CONCACAF and other confederations that might have another confederation competition. So here, when we look at, I think it's paragraph number 6 of 9.2c, confederation competition means the premier competition. The next exception we introduced was the codification of an existing unwritten exception. It's sort of commonly known as the Kosovo rule. So basically, players who may hold the nationality of a country which is not a FIFA member, or that country becomes accepted internationally and joins FIFA, and they are then eligible to take the nationality of that country on the basis of their heritage. This provides a pathway and a codified pathway for players to actually represent that association. So here, if a player has played football already for one FA in an official competition before the federation they wish to represent has joined FIFA, they must meet one of 2 requirements. First is that they either held the nationality of the association that has just joined FIFA membership, or in the second case, like I mentioned, where that is a new country and is also a new FIFA member, they obtain the nationality of that association as what we say is as reasonably practicable after the country was recognised by the majority of the members of the UN. So in effect, it's a recognised sovereign state. And finally, also that they meet one of the requirements in Article 6, common nationality, or Article 7, acquisition of nationality. So those requirements in Article 6 and 7 are requirements which demonstrate a genuine link between the player and the relevant association and its territory. And they refer to either birth on that territory, birth of parents or birth of grandparents, or that the player, as we just discussed before, spent 5 years, a substantial amount of time on that territory. The final one, which has been added to the rules, is Article 9.5. And this is an interesting situation which we saw a couple of times and which has been raised by a couple of associations where, under the previous rules, a player was permitted to change association only once. That limitation also exists in these rules. What we see here is one additional opportunity for a player to change the football association whose teams they wish to play for. And that's in the case where a player that has previously changed their association but never been called up by that new association. Be technical here, but they were never fielded in a match, official or unofficial, in any kind of football by the new association. That player has an opportunity to revert back to the previous football association that they were registered for as for their sporting nationality. The only restriction that is placed there, in addition to the requirement that they weren't fielded in any match for the new association, was that they had to have continuously held the nationality of the former association during that time, so they can still demonstrate that genuine link to the old association by holding its nationality. So all of the cases that we've just talked about were either codifications of existing unwritten jurisprudence, or we've seen significant hardship in the past in cases that have been brought before our player status committee. And so in that case, we've provided some limited exceptions to the general rule that change of association is only permitted in certain circumstances. And we've added to those certain circumstances. But as you can see, and as I've explained, they're extremely limited. You have to jump through quite a lot of hoops. And that also assists in providing some comfort that we don't see a rise of abusive nationality shopping effectively, which is what we want to avoid, obviously, when regulating sporting nationality. So that was a long explanation. I'll throw it back to you. I hope I was relatively clear. But, you know, these are the rules that have been adopted as of 3 weeks ago at the time of recording. We'll explain them more as the commentary comes out. We've already had at least 2 applications under the new rules already for a change of association. One has been granted, one has been rejected. There's another 2 in the pipeline as well. So already we're seeing associations utilising the new rules and the new exceptions, as they are intended to be used.
Well, thank you, James. That was very clear and very helpful. Sadly, that's all we have time for today, so we'll wrap it up there. Thank you to Leticia and James for joining us and for giving us their insights as to the changes. For analysis and articles on football law more generally, please go to our website, morgansl.com. If you're interested in signing up to our mailing list, or if there are any topics that you would like to see addressed in a future podcast, please email us at podcasts@morgansl.com. Finally, please connect with us on Twitter, LinkedIn, Instagram and Facebook for articles, updates and news pieces. We hope that you've enjoyed listening and that you will join us for future episodes of Play On.